I believe all the jurors are present, so we'll ask the jurors to be brought in, and we'll move directly into the state's final argument. Welcome back, ladies and gentlemen. I hope you had a good lunch recess. We are now turning for the final closing argument of the state. Mr. Fawcett.
Thank you.
What?
1 week later, what was otherwise a typical Monday afternoon for a young couple ends in permanent heartbreak. Jamie is bleeding so badly, Angela Cade on the 911 call initially thought Jamie had been shot. Can we take some small measure of comfort knowing that Jamie, as Angela reports to the dispatcher, was alert and able to tell Nation she loved him? Or is it worse to know Jamie likely was aware of her impending death and powerless to stop it? Just days before, you'd celebrate your 4th wedding anniversary, surrounded by friends, unaware that one of your guests had betrayed you for years, had already obtained the knife he will soon use to betray you for the last time. Fact-finding is not in play here. The identity of Jamie's killer is clear. He sits 20 feet away. This jury has the advantage to know with certainty that Jonathan Broyhill fatally stabbed Jamie Hahn with the knife he'd recently purchased and brought concealed to her house, and then did the same to Nation, attempting to take his life. And then 2 days later, Nation's desperate hopes of returns to the beach will die. The question now for this jury is, how are these facts treated under the law? Is Jamie a victim of first-degree murder, or is the defendant guilty of second-degree murder? Before we start discussing in detail the law of murder, the state would like to take an opportunity and discuss a few overreaching principles that may guide you in your deliberations as you begin to assess and evaluate the defendant's guilt. The first thing to keep in mind in your deliberations is the state only must prove what the defendant did, what Jonathan Broyhill did that awful Monday afternoon in Jamie's kitchen. The state has no obligation to provide an explanation or a motive for the defendant's violence. The variety of reasons and multitude of factors that may motivate someone to act and make decisions, while often is interesting to know, is never required to be legally proven to convict someone of a crime. The law addresses and focuses on what transpired, not why it occurred. For example, Carol Erickson taking the defendant to Rex Hospital for false MS treatment. Did it happen? Yes. Is it bizarre? Does it make sense? No. But it happened. His Honor will indeed instruct you as to motive. Proof of motive for the crime is permissible and often valuable, but never essential for conviction. If you are convinced beyond a reasonable doubt that the defendant committed the crime, the presence or absence of motive is immaterial. In the end, people are complex. The permutations of people's personalities are limitless. We may never understand or know why someone does what they do, particularly those that commit crimes. In fact, even those that commit crimes are sometimes at a loss to fully admit or honestly explain themselves once caught. Let's consider the defense answers to Detective Morse. As to the embezzlement, it's page 28. What happened in August 2011 that started it? Short on a bill? No, there really wasn't a reason for it. The gallbladder surgery, page 22. I don't know what caused me to tell people that when clearly it wasn't true. Similar as to the false claims of cancer on page 19. I don't know why I was telling people that because clearly I didn't have it. And then Detective Morse's summation. You know, from the outside looking in, I see this person who's been lying to Nate and Jamie about these illnesses, who's been stealing from Nate and Jamie, and is getting ready to come to a head. And you've been carrying this knife for 2 to 3 weeks. You make these travel plans to Vegas. It's like you intentionally wanted to hurt them. And the defendant responds, I don't see it like that. And the defendant goes on to explain he would never intentionally hurt Jamie or Nation. Page 58, Detective Morse reminds him, but you did. The defendant concedes you're right. I just can't wrap my head around that. Now, at times during that interview, the defendant reports to the wheels are coming off the bus, page 21 of the transcript, when he starts to speak about the gallbladder lies, that he was having, quote, a down day, and was not thinking clearly, end quote, when he purchased the knife, page 37. And he mentions thoughts of hurting himself and hearing voices to hurt other people, page 57. These various statements, if found to be credible by this jury, do not change the fact that the defendant is guilty of first-degree murder, attempted murder, and felony assault on Nation. Often people who commit violent crimes are in some form or fashion depressed or down. Being depressed, may provide some explanation for one's crimes, but please understand this does not preclude one's guilt of first-degree murder or attempted murder. In the end, criminal behavior often doesn't make sense. So many of the horrible headlines we are exposed to defy logic or explanation, particularly those that involve taking advantage of a relationship or violating a position of trust or confidence, all of which we have here. Murder doesn't make sense. It's not a normal or rational behavior. The same holds for instances of murders followed by suicide attempts. At times, there may be some obvious motivation, some nice, neat explanation. Other times, we will simply never understand or know why such crimes and acts occur. So the law acknowledges that reality. The law acknowledges that reality. That is why, to convict such complex, misguided, or dangerous people, the law requires proof of what happened, what they did, not why the defendant did it. The second principle to keep in mind as you begin your deliberations is how do you determine one's intent? His Honor will tell you that intent is a mental attitude, seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. You arrive at this intent of a person by such just and reasonable deductions from the circumstances proven as a reasonably prudent person would ordinarily draw therefrom. So in making this determination, you apply your reason and common sense. You apply your reason and common sense. In applying your reason and common sense, you know that people intend the actions that they do. People normally intend the actions that they do, right? Rather simple, rather obvious. So with that, you can look at the result of those actions. For people certainly intend the foreseeable consequences of those actions. You look at the result, and then you can look back. You can extrapolate back and likely determine that person's intent. Your reason and common sense tells you this. You do it every day of your lives. So here, when someone purposely arms themselves with a deadly weapon, a weapon purchased because it can cause bodily harm, then brings that knife concealed to the location of your surprise attack, then you cut, stab, slice an unsuspecting, non-hostile, unarmed, substantially smaller victim who then dies from those multiple traumatic wounds, you can rightly conclude that that knife-wielding attacker specifically intended to kill that person. That the knife-wielding attacker accomplished what he desired. Your reason and common sense tells you that. And any statements of denial or I don't see it like that ring hollow. The suggestion of a mere suicide lacks believability. Just look at the result. The last thing to keep in mind when you deliberate in this matter is this notion of a close friendship between the Hans and Jonathan Broyhill. This sort of touches on the interesting but legally irrelevant question of why. How could he have done this? They were such dear friends. Well, to start, we need to reevaluate this characterization of best friends. Let's be clear, Jamie and Nation did not know Jonathan Broyhill. Jamie and Nation did not know the real Jonathan Broyhill. There was no real, genuine friendship. That is painfully obvious. We know that now. Jamie and Nation did not know that then. Jonathan Broyhill was a strange, self-absorbed master manipulator, skilled at effortlessly negotiating all of his elaborate deceptions, who finally revealed himself on April 22nd, 2013. So the reality, the now known reality is this was not a genuine mutual friendship based on any measure of mutual trust. It was a betrayal. It was a betrayal, and that betrayal burned for years. As you've learned, Jonathan Broyhill's lies are endless. Not sure when, quote, the wheels started coming off, but his felonious victimization of Jamie's business started in 2011. 39 documented thefts of money totaling $46,500 and the following falsified FEC reporting. He invented illnesses and non-existent doctor's appointments. Day for day, month for month, year for year, manipulating Jamie and Nation, consuming their time, their energy, and their good intentions towards them. Relaxing at their home to recover from phantom gallbladder surgery, while Jamie's mother is relegated to the futon in the cat litter room during her mother-daughter visit. That selfishness sums up Jonathan Broyhill, his personality. And not for a moment should you believe the defendant did not intentionally and knowingly lie about having MS. They didn't intentionally and knowingly lie about having gallbladder surgery. That he didn't know what he was doing when he did those things, that he didn't desire to do what in fact he did, such as recovering at the Hans house from non-existent surgery being waited on. Regardless of any depression or down days, he does what he intends to do. Just like everything else in Jonathan Broyhill's life, he does exactly what he wants to do, what he plans to do, and what he intends to do for whatever reason, no matter how strange that reason may be. Defendant simply uses any and everyone. The Ken Broyhill text, that's another striking example of the level of deception this man would engage in. Consider the thought that goes into that. It's about 40 words, right? Quickly typing out. But consider the thought, as brief as it may be, and typing that out and sending it. It's bizarre. Sure. Did he intentionally do it? Absolutely. The pancreatic cancer, complete fabrication. You'll recall, if you look at the evidence, he's Googling starting at 10:09 on the way to Duke Hospital about oncologists, and through to about 11:32 a.m. He's probably in the car on the way there with Jamie and Nation, and as they're waiting in the waiting room, he's touring the hospital, delaying their already delayed vacation. The Whipple procedure by 11:32. Tuesday, the 9th, that's the spot. At 5:09, the defendant starts to Google various pancreatic cancer. This one specifically, is it possible for a 30-year-old to have pancreatic cancer? Think of the acting job the defendant engaged in upon his announcement that Tuesday, shortly after 5 o'clock, the work hours, and Nation's there, and Jamie's, come on home, John's got bad news. Strange, bizarre. Think of the acting job. Jamie, Nation believed it. He did it. He intentionally did do that. He intentionally did exactly what he desired. He lied about his job at LabCorp. He lied about being terminated from LabCorp. You'll recall that elaborate email that he sends that Friday morning, purportedly from the beach, with descriptive language of feeling, you've seen the email, the walls crashing around him, quote, feeling, quote, suffocated, needing, quote, a breather from the chaos. Descriptions you may find similar to the, quote, wheels are coming off the bus language he would later use with Detective Morse. When his bank records clearly show that he's not employed at LabCorp, he's drawing unemployment, and he's frequenting local businesses instead of being at the beach, those relevant time frames that he's saying that he's at the beach after being fired. Was he not thinking and doing exactly what he wanted to do during those days? Was he not thinking and doing exactly what he was telling Jamie and Nation about the lies? Was he not thinking and doing exactly what he wanted to do when he goes? You can look at the records where whatever fast food restaurant or the food line is one of the businesses he frequents. Every aspect of Jonathan Broyhill's life was a lie. His relationship with Jamie and Nation was no different. So once you expose the defendant for who he is, once you understand and realize this was solely a one-sided relationship, a very profitable relationship that the defendant took every advantage of, then the initial, somewhat head-scratching aspect of this case, that the best friend did this, it's not hard to accept, because that entire premise is a lie. We know that now. Jamie and Nation did not know that then. So with those three principles or observations, the state's burden to prove what happened, what Jonathan Broyhill did in this confession case, not why he did it. To use your common sense, look at the result of action to determine one's intent, and then staying ever mindful of the defendant's deceitful nature and his long-term victimization of Jamie and Nation. With those few principles providing you an overarching working framework to guide you in your deliberations, let's discuss the law and see how the law applies to the evidence in this case. And when the state says evidence, we're speaking of evaluating the evidence. A few things. First, remember the attorney's questions are not evidence. Any assertions, personal speculations, opinions, assumptions, wild assumptions are not evidence. The evidence comes from this witness stand. In evaluating the evidence, you'll consider the source and the quality of the information you're being asked to consider. Did you hear the information from a sworn witness who asserted personal knowledge versus someone being asked to comment on someone else's experiences or some reference document that you never saw or some second or third party information speculation? And finally, in evaluating the evidence, you'll consider the weight you will apply to the evidence, the weight you will give it. Is it credible? Is it credible, concrete information, tangible items, documents you can review that are in evidence? So let's look at the possible verdicts here. Here is the verdict sheet. As to Jamie Hahn, you'll have the options of guilty of first-degree murder, guilty of second-degree murder, or not guilty. His Honor will instruct you that first-degree murder is the unlawful killing of a human being with malice, premeditation, and deliberation. Second-degree murder is the unlawful killing of a human being with malice, but without premeditation and deliberation. That's the distinction between first and second-degree murder. His Honor is expected to give you the instructions on the law of first-degree murder and is expected to give you copies of those instructions. If you don't need to take notes are yours, but you will be getting copies of the law, but we will go through it here. As to nation, the verdict forms are two separate crimes: attempted first-degree murder or not guilty, and then another crime that's similar but sounding, assault with a deadly weapon with intent to kill, inflicting serious injury. That charge and the attempted murder, they sound similar, they're separate crimes. You will consider attempted first-degree murder or not guilty. You will also consider assault with a deadly weapon, inflicting with intent to kill, inflicting serious injury, and if you don't convict the defendant of that felony assault, you will consider the lesser included offense, which is assault with a deadly weapon, inflicting serious injury, or not guilty. The state doesn't intend to review the law. The judge will instruct you as the authority on the law, but as to the crimes of the nation, counsel concedes their client's guilt to the lower level felony assault with a deadly weapon, inflicting serious injury. That serious injury Mr. Hahn testified to, that's poignantly symbolized by the removal of his wedding ring and that lasting scar tissue. So you'll listen carefully to his Honor's instructions and decide accordingly. Let's talk about the evidence. Let's talk about the evidence in the case. Let's begin with the defendant's own words, the words of what he did to Jamie. Let's listen.
Stabbing her in the back.
Where first or?
First, yeah.
Where is she at in relation to you?
She's walking behind her.
Oh, okay. You have to help me out here. She's in the kitchen. Is she sitting at the table? Or she's sitting on one of the stools there?
She's sitting, yes.
Okay, your book bag is on that bar, I guess, or stool
Yeah.
by the living room.
Yeah.
You get the knife.
Yeah.
Is her back to you at that point from where she's sitting? It was, okay. And after you stab her in the back, what happens?
So we return to work.
As you just heard from the defendant, Jamie is seated at that kitchen table, safe and secure in her own home without a moment's concern for her well-being, unaware her life is coming to an end. Only at this most vulnerable, opportune time does the defendant decide, and that's exactly what he does. That's exactly what he does. He decides, he considers his actions, his options, then he decides to take a course of action and acts upon that decision. Just as sure as he decided earlier to drive over to Jamie and Nation's house, to park his car out front, to to get out of his car, to decide what to take into the house, which involved the book bag and the concealed knife, and going into the house. Just as sure as those actions, he decides on a course of action in that kitchen. Only then, when Jamie is seated at the kitchen table, unaware, defenseless, does he decide to begin his attack, thrusting that pristine 8-inch blade into her unprotected back. That sweet southern voice that you've heard that Julie Harrell mentioned will soon cry out in pain as she turns and gets up from the kitchen table. Let's listen.
Looking at me screaming.
Mm-hmm.
And her getting up.
Despite experienced counsel's best attempts at impeachment by forceful suggestion, speculation, defense confession is corroborated. It's well corroborated. First, recall Dr. Lauren Scott's autopsy findings, the injuries to the back. You will also consider the defense confession is corroborated by the crime scene itself, and these are the photos of the crime scene. The blood is in the kitchen, not in the office area. The photos depict Jamie's chair on the ground. It's on top of her handbag, and her glasses are on the floor with an apparent blood spot on the glasses, according to Agent Johnson. In front of that chair, Jamie's chair, is Jamie Hahn's notebook that's been identified and is turned to a blank page. The defendant's cell phone is to the left, sitting on that blank legal envelope and some other folders underneath that. The defendant's book bag is found on the stool as mentioned. Detective Morse tells you also that he recovers the knife packaging inside of the defendant's book bag. All of this clearly supports the defendant's statement. It's interesting to note that the defendant's violence only begins when Nation comes home, announces he's getting ready to leave shortly to go exercise, and goes upstairs to change clothes. Also interesting is the defendant told Nation he wasn't sure if he was going to stay the night, but that he brought clothes. As you know, there was this 7 o'clock Phantom Duke oncology appointment the next morning. The evidence, however, does not suggest the defendant brought clothes for the next day. You see no clothes in the car, hanging clothes in the Volvo. Detective Morse didn't recall seeing any clothes in the search of the car. You heard the defendant was well-dressed that day in a button-down Ralph Lauren shirt, designer jeans, and loafers. You recall his stepmother, Daryl Broyhill, yesterday testifying defendant. He was, quote, "liked to dress well," end quote. Quote, "he always had nice clothes," end quote. The mere T-shirt and shorts found in the book backpack would not be reasonably the defendant's normal attire. Counsel questioned Detective Morse about this point and about whether someone who was going to commit suicide would need a change of clothes for the next day. That begs the question, why then would such a person worry about canceling a flight that you're not going to make in Charlotte? It hasn't occurred yet. You're just not going to make it an hour before you're within an hour of going to Jamie's house, if you want to look at the records. And then rebooking Amtrak travels plans within an hour before your 4:30 arrival at the Hans. Why do you need to seek a $34 refund if you're going to kill yourself? Let's talk about Nation Hahn. Remind yourself, this is not a circumstantial case. An eyewitness to Jamie's murder, a survivor himself, testified, and he testified over the course of 3 tedious days of probing questions, no doubt. You will judge the credibility of Nation Hahn as any witness. His Honor will tell you about judging the credibility of a witness. In deciding whether to believe a witness such as Mr. Hahn, you should use the same test of truthfulness that you use in everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences upon which the witness testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in this case. So in so doing, you'll ask yourself, is there any reason why I should not believe Nation Hahn? Is there anything about his testimony that's inconsistent? You'll recall that Nation testified that the defendant was standing over Jamie, who's now lying on the kitchen floor, and the defendant is holding this large knife as he turns from the stairs. Nation testified the defendant then comes at him with that knife raised and attacking him. What is the defendant's intent at this point? What is the defendant's intent at this point? Use your reason and common sense. Look at what the defendant just did to Jamie Hahn with that same now blood-stained knife. Looking at what he just did to Jamie Hahn, you can confidently conclude, as the defendant now has that knife raised and attacking Nation as he defends himself, that he is trying to attack and kill Nation Hahn. Your reason and common sense tells you that. Mr. Hahn told you about the path to the kitchen was blocked by the defendant. As he comes down the hallway, Nation is able to yell to Jamie, and he's marked for you on these exhibits where states 40, he marks where the defendant and Nation encounter each other in the hallway before the breach of the kitchen door. He's marked on states 113 how Jamie, he sees her legs laying out. You've seen the blood on the floor around that area in the kitchen and a little bit maybe on the carpet there of the living room. He yells to Jamie to get up and run out of the house. She's able to do that. She goes out the side door. Nation defends himself from the defendant's felonious knife attack, and then he flees for his life as well. He's got to go back down the hallway, according to his testimony. He then will turn and go into the dining room. You'll see the broken gate that's left with apparent blood stains in the hallway in State's Exhibit 40 and Agent Johnson's testimony. You know, Agent Johnson testified that in State's Exhibit 41, at the foyer there, as you turn right to go into the dining room, she circled where she found various apparent blood stains on the vase and the wall and the picture frame in State's Exhibit 41. And then in State's Exhibit 106, she circled for you on the wall. There's blood stains on the outer front wall and the outer side wall. And then there's apparent blood stains on the dark hardwood floors in States 106 in the dining room. And you hear about another baby gate, animal gate on the floor in the dining room. All of this, the physical evidence, corroborates Nation Hahn's testimony about his exiting from the house. The very fact that is his flight path from the house leads credence to his testimony that he's defending himself from the defendant in the hallway. Nation also doesn't risk trying to go out the front door and having to turn his back and pause to open the door to get out of the house. Angela Cabe's testimony, State's Exhibit 16, provides you about seeing Jamie up on the stairs here at the corner house, Nation coming down Tillwood Place. That helps signify to you an order and separate departures from the Tillwood house that day by Jamie and Nation. And then Agent Johnson has told you, and you've seen photos of what appear to be two distinct apparent blood trails from Nation's house, one going down the street and then the other to the corner house before joining in front of the Harold's house. Finally, Nation's testimony is consistent, you should find, with Detective Smith's testimony about interviewing Nation in the hospital just right after these assaults in that lonely triage room. While we're talking about the defendant's assault on Nation, the state would like to address the defendant's stated failure to recall certain aspects of his violence that day. Even assuming the defendant's veracity as to this later point, the countless other wounds he inflicted after he first stabbed Jamie in the back or any part of his assault on Nation, not being able to recall that, or I think the quote is vaguely recalling being in the ambulance. That does not alter the fact the defendant indeed committed these 3 separate offenses. You recall Officer Smith's testimony. Officer Smith was there and observed the defendant right after this and interacted with Mr. Broyhill immediately after the events inside the house. He told you the defendant's appropriate compliance with the various officers out there in their directions to exit the house. Officer Smith witnessed the defendant's significant self-inflicted wounds. He told you the defendant was responding to the EMS questions that Officer Smith rode in the ambulance to Wake Med with the defendant. And the defendant was able to provide Officer Smith his correct biographical information, cell phone, address, name, date of birth. They had to go back twice to, I think, another time to confirm the address. Someone thought that wasn't the right address on Glascott, but it was. As an aside, some of you may question the defendant's sincerity as to this point. Let's listen.
That's all I remember. That's all I remember. I'm sure we had to go other places. I'm confident, but
Okay.
that's all I remember.
We know the defendant's well-established credibility issues. He's falsely claimed before memory issues with his MS, and his nation told you about not remembering going to the beach after being terminated from LabCorp. But you also recall in this interview, the defendant wasn't particularly forthcoming with Detective Morse about the details of his plans to leave town. In fact, it took a rather pointed question by Detective Morse, you may find, for the defendant to reluctantly reveal some aspects of his travel plans. Let's
What
listen.
was your thought about, after this happens, you going home? Where are you going to go
After a while.
after this happens right here? You just going to go home?
After,
Yeah. Well, if the police hadn't shown up, and what happened. I mean, were you going to run away, go home?
I hadn't thought about that far. It was totally went blank, and I didn't think about it then. I didn't think about it that far.
Okay.
I did.
Now, just like I told you earlier, my job is to find the truth. And one of the things I want to do is not only look at your phone records, your email records, your accounting records. There's no trips out of the country to flee, nothing like that. There's no afterthought.
I will say this. I was going. It had gotten so bad. I actually thought about going to Las Vegas to kill myself, but I canceled the trip.
Okay, when did that come about?
Mr. Broyhill goes on to speak about purchasing the Vegas flight with his own debit card number. We know that's not true. He used Nation's credit card number, stolen that Monday the 15th, somewhere around 2 a.m. in the morning, as Jamie and Nation are safe and secure in their bed. Mr. Broyhill is also rather, you may find, adamant in his tone that he had no other plans to leave town. Again, that's not true, as we know. Let's listen.
Any other plans for travel?
No.
Ask yourself, if you mentioned the canceled Vegas flight that he was not going to make that day, what should you conclude as the defendant failing to mention the still pending Amtrak travel plans for Tuesday morning? In his search for a Tuesday Charlotte to Vegas flight that he made, and you can look at the records, the internet search for that Tuesday flight occurs before he even calls Amtrak at 3:51 for 5 minutes. He'd already searched for Tuesday flights before he calls Amtrak and has a Tuesday outstanding reservation with Amtrak now. Just like those false statements, you may find the defendant's alleged lack of recall is in fact the defendant again not wanting to fully admit to his actions, not wanting to explain to the investigators how he indeed inflicted this horrific cut or that severe wound or this traumatic injury to Jamie's side. The defense suicide attempt also proves his knowledge and his understanding at that time of what he'd just done to Jamie and Nation. When Jamie and Nation are able to escape the house to alert others, the situation is hopeless, the Amtrak ticket will not be used the next day. Defendant demonstrates his consciousness of guilt, his awareness of his brutal assaults on Jamie and on Nation by attempting to take his own life and continuing to state his desire to die while in police custody in the ambulance. Finally, as to the defendant's attempt on his life, the evidence is here for you to request and to view and see. The audio recording of his interview states 83. The transcript, the illustrative transcript, states 84. I think on page 54 and 55, you may recall despite maybe some yes/no answers by Detective Morse, and this will speak for itself, whatever's on the recording, you may find on page 54 an accurate transcription of the recording of the interview of Detective Morse asking, okay, do you remember hurting yourself? Defendant says, I remember feeling numbness in my hands, is his response. Where were you when this happened? I was in the house. Question, where in the house? I was in the kitchen. Okay, where's Jamie and Nation at this point? I don't remember seeing them. Okay, so you're feeling numbness in your hands. What else do you remember? I just remember laying down. Do you remember the police coming? And he starts talking about the police screaming for him. You may find that at some point, didn't want anybody to be confused, there might have been some questioning by a counsel to Detective Morse about, he just told you about what happened and now he's saying that he doesn't remember Jamie and Nation. Just the context is different, as you'll clearly see. This is after the events that have been talked about, and this is now the defendant is injured himself and getting ready to lay down the floor. That's the context of page 54, 55, if there was any type of uncertainty as to that particular point. Again, these items are evident. It's your recollection and your recollection alone that will determine the facts in this case. Let's talk about what the law of first-degree murder is. Premeditated murder, often for just premeditated murder. Premeditated murder, the layperson's understanding of premeditated murder is probably the Hollywood version, and certainly all the classic elements of that stylized fictional version are present here, right? The embezzler's betrayal, train tickets obtained, flights booked, internet searches of passport requirements to other countries, the murder weapon purchased ahead of time and brought to the location of the surprise assault. But as we will see, under the law of premeditated murder, it doesn't require such elaborate preparation or contemplation or planning. The law only requires the defendant form the intent to kill over some period of time, however short, before he acts in a deliberate manner. This can be as far back as the purchasing of the knife on the evening of the 14th. It can be as short as walking into the kitchen with that knife to stab Jamie Hahn in the back. Let's review the law of first-degree murder. And again, His Honor is the authority in the law. His and his alone is the law. And it's expected that these will be consistent with some of those instructions and that you will have a copy of. Generally, there are 5 elements to first-degree murder with malice, premeditation, and deliberation. The first element is killing with malice and a deadly weapon. The second element is causation. The third element is an intent to kill, a specific intent to kill. The fourth element is premeditation. And the fifth element is deliberation. So 5 elements. And now here is the law as to those 5 elements that will control this jury's decision. Let's read these. First, that the defendant intentionally and with malice killed the victim with a deadly weapon. That is the first element. Second, The state must prove that the defendant's act was a proximate cause of the victim's death. Third, that the defendant intended to kill the victim. Fourth, that the defendant acted after premeditation. That is, that the defendant formed the intent to kill the victim over some period of time, however short, before the defendant acted. And fifth, that the defendant acted with deliberation, which means the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Those are the 5 elements the state must prove beyond a reasonable doubt to this jury to obtain a conviction of first-degree murder in this case. Let's start with the first element. First, the defendant intends, the more repetitiveness of this, the state believes, the better for you as you will digest this material. First, that the defendant intentionally and with malice killed the victim with a deadly weapon. His Honor will tell you that the chef's blade is a deadly weapon. Let's look and see what malice means. His Honor is expected to inform you that malice means not only hatred, ill will, or spite, as it is ordinarily understood. To be sure, that is malice. But it also means that condition of mind which prompts a person to take the life of another intentionally, or to intentionally inflict serious bodily harm which proximately results in another's death without just cause, excuse, or justification. His Honor will instruct you that if the state proves beyond a reasonable doubt that the defendant intentionally killed the victim with a deadly weapon or intentionally inflicted a wound upon the victim with a deadly weapon that proximately caused the victim's death, you may infer first that the killing was unlawful, and second, that it was done with malice, but you are not compelled to do so. You may consider this along with all of the facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. And malice must be proved in both first and second degree murder. That is the definition of malice the state must prove. So back to the first element. For first degree murder with premeditation deliberation, the state must prove the defendant intentionally and with malice killed Ms. Hahn with a deadly weapon. All right, that's the first of the 5 elements the state must prove beyond a reasonable doubt to this jury. The second element, straightforward, it's causation. His Honor will tell you that the state must prove that the defendant's act was a proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred, and one that a reasonably careful and prudent person could foresee would probably produce such injury or some similar injurious result. That's causation. That's not an issue in this case. The state must prove it beyond reasonable doubt. But all right, so that's the second of 5 elements. The third element is back to an intent to kill the victim. And you'll recall again my remarks earlier, excuse me, about intent. The intent that the defendant intended to kill the victim. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. Intent to kill may be inferred from the nature of the assault, the manner in which it was made, the conduct of the parties, and other relevant circumstances. You recall the state's earlier remarks about intent. You will recall Dr. Scott's autopsy findings and all of the autopsy photos of Jamie's multiple injuries. So that's the first 3 elements. And the fourth and fifth here are premeditation and deliberation. And this is where the state would like to concentrate its comments because it is expected this jury will do the same on the fourth and fifth element Let's look at the fourth and fifth element. As we know, as to the fourth element, that's the premeditation element. As we know, does not require elaborate thought or planning, only that the defendant formed the intent to kill over some period of time, however short, before acting. Excuse me. Premeditation, formed the intent to kill over some period of time, however short, before the defendant acted. Accessing his book bag, which is sitting on the stool in the living room, and then walking into the kitchen with that now armed 8-inch chef's blade, well satisfies the brief period of time needed for premeditation under the law of North Carolina. That is premeditation. As to deliberation, certainly those that act and take a life are acting often with high emotion. The adrenaline is pumping, pulse rate rising, mind racing. That intensity is to be expected. It is immaterial under the law of first-degree murder that one may have such high emotions, or even that the defendant is maybe agitated or stressed or overwhelmed by his lifestyle of lies finally catching up with him. The focus of this element, the focus of deliberation, is regardless of that excitement, regardless of any passion, did the defendant act with a fixed purpose to kill? Did the defendant act with a fixed purpose to kill? Fifth element, deliberation. He acted with deliberation, which means that the defendant acted while the defendant was in a cool state of mind. That does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Here, there is no evidence that the defendant was suddenly and violently baited or incited into killing Jamie Hahn and just conveniently had the murder weapon available. There's no evidence of any heated argument between Jamie and Nation before he begins to assault her. There's no evidence of any mutual fighting words or an affray that escalates into a fit of rage. My apologies. Defendant indeed denies any such precipitating event occurred between them. You'll recall that Nation Hahn testified that there was no suspicion of theft. There's no suspicion or plan by Jamie to confront the defendant about any, whether it's $500 or $900. He tells later that in front of Julie Harrells, he has, quote, leap of logic as to that. But there's no evidence that there was any thought the defendant was embezzling money or any thought or plan for Jamie to confront him. As to the purpose of Jamie and the defendant's meeting that Monday afternoon, you know what materials Jamie had been requesting on the various emails and evidence for the defendant to turn over that day. You heard Jamie's voicemail, I think State's Exhibit 96, to the defendant that they were going to discuss, bring all the, I think, quote, all the Brad stuff. You can revisit any item of evidence you need. You know all the unresolved issues with the Miller campaign, and now these recent FEC letters requesting information. Jamie on that voicemail tells the defendant to come over, I think it says about 4-ish, I think it's the quote, in case they have to get with the bank or check with the FEC before the close of business, to bring the bank stuff in the mail key. Those are the facts of the case. That is the evidence of the case. That is the purpose of the defendant going over there, of the meeting between the defendant and Jamie Hahn that Monday afternoon. Nation told you everything appeared fine when he got home from work. Just like his other interactions with Jonathan Broyhill, he seemed normal. Regular Jonathan. They hugged, talked, and Nation goes upstairs after announcing he's getting ready to go exercise. Nation upstairs does not hear any raised or heated voices between his wife or the defendant. The only sound Nation hears is Jamie screaming from the pain and horror of that penetrating 8-inch blade as it severs her liver and slices through her lung. That's compelling evidence of a deliberate killing, of a cool state of mind, of a fixed purpose to kill. That is powerful evidence of deliberation. So, these are separate elements, premeditation and deliberation. The state must prove both. But, as His Honor will inform you, there's often your analysis of the facts and the inferences you will draw from those facts often apply equally to both. The facts and the inferences are often equally probative to premeditation as well as to deliberation. As His Honor will tell you, neither premeditation nor deliberation are usually susceptible of direct proof. They may be proved by proof of circumstances from which they may be inferred, such as the lack of provocation by the victim, conduct of the defendant before, during, and after the killing, use of grossly excessive force, brutal or vicious circumstances of the killing, and the manner in which or means by which the killing was done. So you look at the circumstances for both these elements, premeditation and deliberation. The lack of provocation by Jamie Hahn, we've just addressed. The excessive, brutal, vicious circumstances of the killing are well apparent, as is the defendant bringing the murder weapon concealed to the house that day. Let's look at the manner and means of this killing, because that certainly speaks to both premeditation and deliberation. The nature of the weapon used here, a knife. The number and locations of wounds involved all point to numerous, individual, time-consuming, thoughtful actions. They're undertaken clearly to take a life. They're undertaken with a fixed purpose to kill. Numerous, thoughtful, time-consuming actions. The nature of the weapon, a knife. The location and number of wounds. Another common sense correlation between the fourth element, premeditation, and the fifth element of deliberation is that the longer period of premeditation, right, the longer this period of premeditation is, the greater the evidence that this was a deliberate killing as well. Again, reason and common sense tells you this. Let's remember the defendant had to go to the Harris Teeter, had to go to the store specifically to get this knife. What does that mean? Well, you drive to the store, you get out of your car, you walk into the store, all the time thinking, doing exactly what you intend to do. All right, you're in the store. Where's the knife section? You then go to the knife section. You look at the various knives available. What knife will you select? Will you select one of these smaller blades, these paring knives? No, I'll take the 8-inch chef's knife. The picture you very well may find does not do it justice, as you saw that when Detective Morris opened it up and actually showed you just how substantial this deadly weapon is. You then take this knife and you conceal the knife in your book bag. You drive over to Jamie's house that Monday afternoon. Did you leave the knife in the car? No. Why? You bring the knife into the house. And then remember, this is a brand new knife. You just bought it a week ago, 7, 8 days, however you want to calculate that. When did you cut off these strong, tedious plastic safety fasteners? I mean, there's two ways to getting these things. If you're strong enough, you can rip this thing out of the packaging. We know the defendant did not do that. You can look at State's Exhibit 91A, and you can see the 4 holes are still completely intact. And this is a substantial knife. This is a substantial protective packaging, State's Exhibit 91. So the only other way is to cut these plastic safety tabs. And under the best of circumstances, you may find those things are tedious and under the best of circumstances, difficult to get off the packaging. So you already had that knife prepped for use in your book bag, concealed when you went to the Hahn residence Monday afternoon. All of this is powerful evidence of planning, of premeditation, and that significant evidence of preparation is equally applicable to a deliberate killing. Your reason and common sense tells you that. Again, you don't have to, premeditation can start as far back as April 14th at 7:40 at night. It can occur right in the kitchen. But again, you had to have that knife ready for use, that substantial knife that you're carrying around in a book bag going to her house that day. Notwithstanding the substantial evidence of premeditation and deliberation of bringing the murder weapon to the house concealed, let's reduce the relevant time period of your inquiry. Let's analyze whether the defendant acted with premeditation and deliberation by just concentrating on his actions in Jamie's kitchen, and just as to this discrete period of time, consider the mechanics of what the defendant had to do. Really consider the minutia of all these individual thoughts, time-consuming actions, and movements that are involved in the defendant successfully executing his deadly attack. The book bag is sitting on the stool in the living room. At some point, defendant must go to his book bag to get this concealed knife. That's time, that's movement, that's thought, that's intention. Once he decides to go to the book bag, this jury could reasonably conclude the defendant is committed to using that deadly weapon. So now, the defendant is at the book bag. Let's forget for the moment we know what's getting ready to occur. Let's put that aside. Let's just concentrate to see if we have premeditation and deliberation as he stands at this book bag. We don't know what's going to happen. From this point forward, at the book bag, is the defendant going to take his life, as counsel contends to this jury, or is he going to take the life of another? So he's at the book bag. Which way is this going to go? He must access the book bag in the living room that's on the stool there. What does that mean, access the book bag? You've heard it has 3 compartments. There's zippered compartments. You've got to think, where did I put the knife? Which compartment is in? I need to access that specific compartment. I then need to locate that knife in that particular compartment. You then must grab and secure the knife. The hand of your choice, presumably the hand you feel most comfortable with the greatest chance of success or skill in using. You may find that it would actually require you to use 2 hands to slide it out of the protective packaging. Maybe, maybe not, but you may so find it might take you 2 hands to do that, to hold the packaging and to take the knife out. All the while, the evidence shows defendant accomplishes this without Jamie Hahn detecting or knowing this. So now you have the knife. You're at the book bag, you're in the living room, you have the knife. Will it be suicide? Will it be murder? At this point, if your sole intention is suicide, then why do you not attempt suicide? Why didn't you start to cut yourself at that moment? What was so attractive about the kitchen? What was so attractive about the kitchen? Think of all the things you could have done and look at what Jonathan Broyhill actually did. Look at the result. Use your reason, common sense. Think of all the things he could have done at that point. Look what he did. The defendant was going to kill himself. Why did he walk back into the kitchen with that knife? If he was going to kill himself, why did he stab Jamie in the back? If he was going to kill himself, why did he continue to cut and stab and slice Jamie Hahn? If your motive was suicide, why is Ms. Hahn in her grave? So at this point, we know with clarity what his intention is. He's going to take that knife, and he's going to walk into the kitchen where Jamie Hahn is seated at her chair that's now on the floor with her back turned to the defendant. The intent to kill formed over some period of time, however brief. After the defendant walks into the kitchen, he's got to position himself behind Jamie, and he must consider where he's going to first insert this knife, where he first is going to stab or cut or slice Jamie. He's got to focus on his target that he decides on, and then he must act on that intent. You look at all the things Jonathan Broyhill could have done at that moment, and then you look at what he actually did with that knife. You look at the result. The stabbing motion itself involves some time, contemplation, and movement. He has to extend his arm out in some form or fashion. You don't know how, but he has to extend his arm out with some force with that knife to assault her for the first time in her back and for the many times to follow. Those are the minute mental processes at work here. Those are the endless physical movements that must occur as defendant executes his knife assault on Jamie Hahn. So those are the 5 elements the state must prove. Just consider someone describing the following. The killer bought a knife. He then brought it concealed to the victim's house. When the victim's back was turned, the killer produced the knife and started stabbing her in the back and numerous times to follow. And ask yourself, what could that be? What could that be other than premeditated murder? The state respectfully would request that you convict Jonathan Broyhill of first-degree murder of Jamie Hahn. A few concluding observations. The state would like to put in context the timing of the defendant's purchase of the knife, the context of the time of the defendant's purchase of the knife, and his state of mind as this narrative comes to a painful conclusion in the month of April. Even though the defendant does not work for Sky Blue in 2013, you know the evidence shows the defendant still retains possession of various campaign property and financial materials. This is the list of the request from Jamie, the defendant, on April 8th, the Monday, the day before the spot diagnosis. And these are a list of various items she's requesting. The defendant knows somewhere in these items, when they are to be turned over to Jamie, that she will inherit is evidence of his incriminating financial and lengthy wrongdoing. Somewhere in that list, particularly the bank account information and bank statements, and you see these other things, all details and transactions regarding state account and Fed debt payments, first quarter payment info, John Wallace reconciliation forms. You can look at this evidence again if you so request. So now Jamie is requesting to demand these items. She needs an accounting of what she is now taking ownership of. And for the first time, Jamie Hahn is going to start looking at the financials. She's going to start looking at the books. Defendant concedes to the investigators that Jamie was not looking at the books, that was the defendant's sole responsibility. The month of April brings urgency to this transfer of property and financials and debriefing process, as the necessity for the first quarter FEC filing is due on April 15th. And again, this requires Jamie for the first time alone to prepare the documents, to state the bank balance, to normally justify the bank balance to Treasurer John Wallace with the PNC bank statements. Whether the defendant before April 15th knows the bank account is in the negative, at a minimum, the defendant knows the books and bank statements Jamie will inherit will be his undoing because of his 2 years of embezzlement. He concedes as much as Detective Gill, at page 73 of the transcript. Bottom line, that those FEC numbers not going to match up. Bottom line, he concedes that. Defendant is therefore motivated throughout the month of April by the knowledge he is close to being caught. That's his motivation. He's close to being caught. His extensive financial crimes will soon be detected. So that's his state of mind. That is what is important here. What the defendant knew, what the defendant thought, his expectations of what was certain to soon occur, not what Jamie did or didn't know or did or did not suspect. So as the April 15th filing deadline approaches, defendant knows that's the date he reasonably can expect to be caught. That's why he considers his position in the weeks prior, recovering from gallbladder surgery, the further pancreatic cancer diagnosis as a possible sympathetic additional distraction. And he continues to avoid meeting with Jamie Hahn to transfer the financials, to give her the bank statements, as he considers his options. Then he buys that knife. He buys that knife on Sunday, April 14th at 7:40. The timing of the purchase of that knife is informative. He buys that knife at 7:40 that Sunday at the Harris Teeter, located less than 2 miles from the Hans house. This is the meeting right before he's getting ready to go see Jamie. It's the meeting that he has so feared that he cannot avoid anymore. The FEC filing is tomorrow, reasonably expecting that he will not escape detection once Jamie demands to see the PNC bank statements or other supporting financial documents. That would be the defendant's mindset on April 14th on that night. Now, the defendant would have investigators believe that the purchase of this knife was, quote, down day and, quote, not thinking clearly, that he was going to commit suicide. Ask yourself, who must leave their house to go purchase a chef's knife to commit suicide? Why do you leave your house to go to the Hans house to commit suicide, whether on the 14th that evening or on the 22nd? Why do you go to the Hans house on either night to commit suicide with that knife? Most insightful, you purchase this knife before seeing Jamie Hahn, knowing what the topic is of these outstanding Miller issues, and that what you're getting ready to see. What is she going to request? What is she going to demand? What is she going to ask of me? Also telling us the defendant does not share this curious timing with Detective Morse when he's interviewed about the purchase of the knife. The reason is this context puts a different narrative than solely a suicidal predisposition. Just like the travel plans not shared with Detective Morse, you might reasonably conclude a more incriminating motivation to this knife purchase at 7:40 that Sunday. But we know that defendant that night is able to satisfy any questions or concerns Jamie has, assuming she had any that touched on issues of importance. We know the defendant would not have a hard time satisfying given his well-practiced skills of deception, but we know nothing occurs that night. No embezzlement is detected. No violence is committed. No violence at all is committed that night. The only crime is the defendant's unauthorized access of Nation's credit card about 2 a.m. that morning when Nation and Jamie are asleep. And the access of the card for a vet, that's not until Friday, when there's a phone call and Nation supplies that credit card number to the defendant for the vet that Friday morning as the defendant is getting ready to come down to the beach. Let's be clear about the timing of those two things, what the evidence shows. So once Jamie is successfully appeased, the Wallace meeting the next morning is probably not a significant event of concern for the defendant. You may find that John Wallace, like Jamie Hahn, placed great trust and faith in Jonathan Broyhill and ceded substantial financial responsibilities or oversight to the process to Jonathan Broyhill. We know there's no reason to doubt him, right? We know no question was raised about the $60,000+ stated bank balance on the proposed FEC form. Unlike normal quarterly meetings, we know no bank statements were provided to John Wallace to justify that number. He was only showed the proposed filing with that falsified, later to be determined falsified bank balance. So whatever time the defendant thought he gained after that meeting on the 15th Monday morning, whatever brief respite he thought he secured, that afternoon at 3:23 is where the defendant's already shaky financial house of cards crashes down on him.
Mr. Oliver?
Yes.
Hi, this is Jamie Hahn, Brad Miller's campaign.
Yes, ma'am.
With that, Jamie sends this text to the defendant, tells him the Time Warner cable check is bounced, requesting the defendant to send the online info to sign into the bank account so she can now check this bounced check according to the bill collector. At this point, the defendant knows he's caught. He may take pains to deflect the significance of this point when he speaks to Detective Gill, sort of like telling Detective Gill he could clear up the FEC letters with just a a phone call. I think even counsel conceded, well, maybe one of those letters you could maybe do with a phone call, but defendant overextends himself. You may find the same significance to this bounce check because it is significant. Just as the defendant knew that this was significant when he would lie to Mr. Williford a few days later, when Mr. Williford calls and talks to him about it, and this is the first I've heard of it. He knows, the defendant knows the significance of this. At best, he tells Detective Gill, in the back of my mind, I thought it could have been a theory that the account now is bankrupt. Whether this is a non-issue, this jury will judge the credibility of that point. The state contends by sending this instant message to the defendant, Jamie Hahn confronted, unknowingly, but confronted the defendant with evidence of his embezzlement. When Jamie returns from the beach, Jonathan Broyhill's life of fraud and deceit will be revealed. Incarceration awaits. So that is the defendant's mindset on Monday, April 22nd, 2013. So armed with that knowledge, armed with that 8-inch chef's knife, the question is, what will Jonathan Broyhill do? What will he do? Whatever Jonathan Broyhill plans to do next, we know it will not involve a suicide note. Members of the jury, the state has proven what Jonathan Broyhill did, what the defendant did. As equally clear as the facts are, the facts of what Jonathan Broyhill did are the legal conclusions the state urges this jury to draw from those facts, convicting the defendant of first-degree murder, attempted murder, and the assault with a deadly weapon with intent to kill, inflicting serious injury. This jury should not discount the incriminating timing of the kitchen knife purchase, the context of that, and the defendant's knowledge and expectations on both the 14th and on the final 22nd of April. Whether Jonathan Broyhill is the most twisted, calculated killer, or whether he is a despondent, broken person who made uncharacteristic, violent decisions that day, or even if the truth lies somewhere in between, is of no legal consequence. This jury will not resolve that question. Your sole mandate is to apply the law to the facts of what happened. No matter how strange or self-defeating the defendant's violence proved to be that Monday afternoon. For crimes are not defined by how wise or how smart they may appear in hindsight. A hope of success is not an element of murder. In the end, Jonathan Broyhill did this. He did this. He did what he intended to do for whatever reason or reasons, no matter how strange they may seem to you. His consistent self-centered conduct and deceptive behavior culminated that April afternoon with his purposeful, determined, and heartbreakingly successful knife attack. A knife that he brought concealed to the residence that day. And now is the time we arrive at justice. Now is the time for you to convict the defendant for selfishly taking Jamie's life, leaving Nation too young to be a widower, to think of the times he shared with the wife he so adored. Thank you.
Thank you, Mr. Foster. Ladies and gentlemen, we're going to take a 10-minute recess until 5 minutes till 3. Then we will proceed with the jury instructions to you. Please recall all the instructions. Don't talk among yourselves or with anyone else about the case. Don't form or express opinions about the outcome. No media or independent investigation into these matters, and no conversation or communication with parties, witnesses, or lawyers. If you'll leave your notepads in your chairs, gather at 5 minutes till 3. Everyone else, please remain seated. All right, outside the presence of the jury, we'll be in recess until 5 till 3. one brief matter at bench we'll discuss when we come back. We'll go ahead and break now for 10 minutes, then we'll gather at the
Post
bench.
has a recess to 5 minutes.